because at times it's impossible to escape the conclusion that life gets sillier and sillier. And yesterday gave rise to an extraordinary decision by the unelected High Court. The decision, which some have called racist, was described by the Institute of Public Affairs research fellow Morgan Begg as, quote, the most radical instance of judicial activism in Australian history. The court ruled by a majority of 4-3 that Aboriginal people, even Aboriginal non-citizens born overseas, cannot be considered aliens under the Constitution, and they can't be deported on character grounds. The case concerned two Aboriginal men who were not Australian citizens and who were born overseas. Both men faced deportation on character grounds after committing separate violent assaults in Australia. Their lawyers challenged their deportation on the basis of the men's Aboriginality, and the High Court ruled in favour of that argument, finding that Aborigines cannot be classified as aliens regardless of whether they are citizens or not. To use the language of the court, Aboriginality, majority language, deriving from either biological descent, self-identification or recognition by a traditional group, places individuals outside, quote, the reach of the alien's power conferred by the Constitution. The court defined a new category of person described as a belonger, who's neither an alien nor a citizen, but who is nevertheless owed protection by the Crown. Alarmingly, the new principle can only be overturned by referendum or by a future High Court. Scott Morrison must be shaking his head, knowing the public won't cop this. Chris Merritt, the Australian newspaper's legal affairs editor, doesn't miss on this High Court decision. Basically, two blokes claiming distant Aboriginality, I mean great-grandfathers and all that stuff, were to be deported. They weren't Australians, they had no citizenship. One was born in Papua New Guinea, the other in New Zealand. They have an Aboriginal connection from way back, grandfather, great-grandfather or something such. Basically, the High Court in this judgment, 4-3, found that because they identify as Aboriginal, they could not be deported. Now they're wanting damages for false imprisonment. Now, unless I'm mistaken, this doesn't pass the pub test. Chris Merritt goes to the guts of it. He talks about, quote, the lunacy of the decision, and then says this: this is pure racism built upon an illegitimate exercise of judicial power by the narrowest of margins. The nation's highest court has elevated a racial distinction to a position of constitutional privilege that would never be accepted if such a question were put to the people at a referendum. Chris Merritt goes on, this shameful ruling has punched a hole in the principle that everyone's equal before Australian law and has eroded the federal government's ability to protect the community from foreign criminals who've never tried to become citizens. He further adds, even when born overseas and holding the citizenship of another country, foreign criminals with Aboriginal ancestry can no longer be treated as aliens for the purpose of migration law. The Merritt argument gathers momentum when he says, the majority has decided that foreign citizens with Aboriginal ancestry have a special connection with Australia, that it would be inconsistent with that special connection to treat them as aliens for the purposes of migration law. He says this principle was applied even though the men who brought this challenge never tried to become Australian citizens. Common sense, he said, has gone out the window. Now, you can't argue with Chris Merritt when he says the majority has invented a new illogical category in migration law that applies only to Aborigines who hold foreign citizenship. They can simultaneously be non-citizens and non-aliens. It should be noted the Chief Justice of the same High Court of Australia, Susan Kiefel, differed strongly from the views of the majority 4. It was, as I pointed out, only a 4-3 decision, but equally, as I pointed out, it can only be overturned by a referendum or a future High Court. The final word belongs to Chris Merritt, the legal affairs editor of the Australian newspaper, when he writes today, quote, the judges in the majority are massively out of step with community values and the core principle of equality before the law.
See, that's the difficulty. The High Court can get it wrong.
Quite.
And as far as the mob are concerned, the High Court are crazy on this.
Well, we're just being told to cop it.
Yeah. Well, I mean, you can't cop this sort of nonsense. Now, the trouble is, once the High Court have done it, it's incredibly hard to undo.
Only a referendum or a new High Court. And it's a 4-3 judgment, and the Chief Justice, Susan Kiefel, allegedly because she's the Chief Justice, the smartest of them all, says this is nonsense.
Well, I don't think you need to be terribly smart to know it's nonsense.
Absolutely.
I mean, this is the trouble with judicial activism. I worry about it, even if it acts in favour of positions that I might want to take. I don't like it. It's a dangerous precedent, this, and Australians should be looking at this very carefully, because you don't really want too much of this judge-made law and not have it a law made by those who you've elected to make the laws.
That's exactly right.
And I really worry about this. This is a problem.
Yeah, these are unelected people.